Good afternoon, gorgeous George fans. It's me, Swedish attorney at law, Marty McFly, bringing you the latest from the Virginia courts. Folks, we got a doozy for you today. Let's jump straight into it. Order. This matter comes before the court on the motion by the plaintiff, George Yarid, to file his third amended complaint with additional counts outside the scope of what the court had ordered. So the court ordered George to file his third amended complaint, but told him to keep it specifically to some copyright issues. George didn't do this, so quite rightly the court denies the motion. The court also denies defendant William Markland's letter motion to dismiss, document number 65, and Yarid's motion to strike that letter, motion, document number 66, as moot. By order dated July the 20th, 2017, the court dismissed the plaintiff's intentional infliction of emotional distress claims with prejudice. That means he can't bring those claims again, and they don't want to hear about it. The court then permitted Yarid to file a third amended complaint containing only his copyright infringement claims. The plaintiff filed his third amended complaint, but added counts for defamation and invasion of privacy. The facts underlying these attempted new causes of action stem in large part from the intentional emotional distress claims which the court previously dismissed. The court permitted Yarid 3 opportunities to plead causes of actions related to the defendant's alleged conduct, and for the same reason stated in its original order on the issue, the court denies the motion to add the new claims. The court will not require Yarid to refile a complaint without his defamation and privacy claims, but the court strikes those portions of the complaint, and this case moves forward only as to Yarid's copyright infringement claims against only Sean Brenan and William Markland. Having addressed Yarid's motion to amend, the court now addresses the responses from the defendants. Defendant William Markland filed a letter motion to dismiss, and Yarid then moved to strike. Markland then filed a motion to dismiss with a Roseboro notice, along with a memorandum in support of his motion to dismiss, document number 67. The court directs Yarid to respond to the motion to dismiss within 21 days of the date of this order. The court will closely scrutinise any request for an extension, considering the fact that the defendant filed his motion on October the 20th, and the court has therefore already extended the otherwise applicable deadline to respond. Markland may file a brief reply in response to Yarid's opposition within 14 days of Yarid's submission. The remaining defendant, Sean Brenan, shall have 21 days from the date of this order to file a motion or responsive pleading to the third amended complaint. It is so ordered. Let the clerk send a copy of this order to all counsel of record and to the pro se parties. John A. Givney, November the 1st, 2017. The third amended complaint does not proceed against defendant YouTube LLC, and the court dismisses the case against YouTube. This order, folks, is serious for George. What it now means is he is left with his copyright infringement claims only, and essentially the judge has had enough of George claiming that he's being emotionally distressed and invasion of privacy and everything else and defamed everywhere. They don't want to hear it, and because they've now been dismissed with prejudice, George has a serious problem that he can't bring those claims again. So if we now move to his his actual complaint, let me get it up for you guys so you can see how ridiculous this really is. Let's open this up. So this is George's third amended complaint. Now, this document's 25 pages long, and it goes on about crap that, doesn't even, it's ridiculous. Remember, folks, George is a private person who lives in the county of Henrico. The Gorgeous George Show, which airs in Richmond, Virginia, is posted on youtube.com. So this is all crap that George was going through. Now, this is where it starts to get funny. So literally from point 11 here in count 1 all the way to here, point 38, has been struck. That's all been struck. Count 6, the copyright infringement of George A. Yarid by Sean Brenan. So this is all Sean needs to respond to, because this is the only claim that George now has. And his only claim against Sean is that on February the 22nd, 2016, Sean posted a video where Sean states that someone sent Sean's film to a film festival. The film in question is entitled Gorgeous George Sucks Movie. This film is George's show covered under his copyright. He boastfully and proudly states in this video he is a troll and was shocked that the film festivals were offering him money for work that wasn't his, but of in fact the copying of constituent elements of George's original copyrighted work. So literally, that is all Sean has to respond to. Everything else has been struck and has nothing to deal with. George then tried to deal with all this, so this has been struck, 41's been struck, 42, 43, 44, 45, 46, 47's been struck, 48's been struck, count 11's been struck, count 12's been struck, count 13's been struck, count 14 is another count of copyright infringement, which Sean would need to respond to, which is Sean's downloaded and posted on YouTube many videos from the Gorgeous George show, which he published thereupon, claiming the same were his original works. I know for a fact Sean has never claimed any of the videos are his original works, other than videos he's done covered under fair use. These videos are not Sean's creation nor property. They're also not George's creation or property. The Uniform Resource Locator, and it lists a load of videos that it's all the movies we've all ever seen. It's all the parody stuff that's all covered under fair use that George is trying to claim is all his. So George just lists hundreds of videos. So that's all done. Let's have a look here. Again, it doesn't really... He still doesn't really claim anything to do with copyright here. It's just all my face is in it, so it's mine. This is all talking about George. So all this has been struck. So essentially 59 onwards has been struck. 61's been struck. So you can see how much the judge is just getting rid of from George's case. This has been struck. Count 15's all been struck. So then there's only one more copyright infringement. So this is really funny. George seems to believe that Sean is responsible for Encyclopedia Dramatica. Well, he's not responsible for Encyclopedia Dramatica. And Sean is not responsible for anything that's published on Encyclopedia Dramatica. It's the people that host Encyclopedia Dramatica that George would need to deal with, so he would need to take them to court, and I'm pretty certain he won't be able to do that. So, you know, going on with numerous and multiple drawings of him that can be viewed depict him as a slob and a sexual predator. Two things he really is. He's a slob and a sexual predator. That make the most human beings incapable of carrying out. It's all just George's feelings are hurt. That's all this is. Again, all about Encyclopedia Dramatica. So, Sean's got to answer about 4 things that he's got to answer. This claim here about Sean being to deal with Encyclopedia Dramatica is nothing at all to do with Sean. Encyclopedia Dramatica was never authored by him, so there's nothing he can do about that. Then we move on to Will. Now, count 17 is the copyright infringement of George Yarid by Will Markland. So, same thing. Will's posted videos that he claims are George, and he reckons that George isn't being paid royalties. Royalties, George thinks he should be paid here. All of this, just normal links to videos, just hundreds of them. Look at him. How sad are this bloke? Just to go through the internet trying to find any video. And then here we go, some returns to George's lovely handwriting here. So that has to be answered. So 68, George calling him a... William has called George on the telephone on multiple occasions in 2016, bullying George, calling him a pauper, laughing at him, telling him that he is going to lose his home and become homeless. Well, if there was something that Will was telling the truth about, it's this. He is going to become homeless. So this has been struck. 68's been struck. And 69's been struck. Count 18 has been struck. And that's it. So Will only has to answer one count, which is copyright infringement. And 98.99% of all this stuff is all covered under fair use. But there's also a few little bits of ammunition that we've got to fire against Mr. Georgie Boy when it comes back to his response. Essentially, guys, Georgie's case has fallen apart. His case against YouTube has gone. His case against Will and Sean is falling down to copyright, which George knows he can't survive any copyright claims because he's been through this so many times before, and the judges don't want to hear it. But also, YouTube believed that it was all covered under fair use and parody. So George has got a real problem with all of this. He's got some serious issues when it comes to this. Now, Marty McFly, being the investigative reporter that he is, I've contacted George asking him for a response on this, to which George has already told me to shut up and there's going to be an appeal. So he is going to appeal any decision the court makes. George would be very, very stupid to appeal any decision the court makes, because George is bringing himself into the grounds of being a vexatious litigant, and that is a very dangerous place for George to be, because that would mean George would never ever be able to file any claims again without permission of Judge John Gibney. And believe me, George, that's what we're going to be pushing for, is for you to become a vexatious litigant, which means you've got to start paying your court fees, but also you've got to start putting bonds into court when you want to issue a claim against someone, so it puts a stop to you altogether. Now, with this, George is he's falling apart. He's falling apart, guys. How long has it been since George put a video on YouTube? He can't handle Marty McFly being in Richmond. He can't handle Marty McFly phoning him up and asking him for comments on newsworthy items with his name in the public. He can't handle that RVA Dirt have recently written an article about him demanding that he's removed from Comcast and Channel 65 due to his comments and the way he behaves on TV. He can't handle that he's losing his house. He is falling apart. So, George, your little claim down here that what you want from everyone is $40,000 in punitive damages and then $40,000 in nominal damages isn't going anywhere. You are going to get jack shit. Your claim has fallen apart. You're going to be defeated at court again and embarrassed again. You're going to be declared a vexatious litigant, which means you won't be able to file any more court cases in Virginia unless you have John Gibney's permission or you actually hire an attorney. You will not do what you have done to people for the last 7 years, which is file court claims because you don't like people criticising what you do, and you don't like people calling you out for the disgusting human being that you are. And if you can't deal with the fact that people call you a disgusting human being, don't go on TV and don't go on the internet calling people fags and homos and attacking people and going after people with learning difficulties. You're a disgusting human being. You're a coward. I offered to meet you last night at 9 p.m. and you refused like the coward that you are, and you would only meet someone if they did it on your doorstep. And we all know the only reason you want someone to be on your doorstep is so that you can call the police, because that's your only protection, because you're so much of a bitch you cannot meet anyone face to face outside of your home. I'm in Richmond. I've offered to meet you 4 times. If I have to produce the text messages and show them on the internet that show you for the coward you are, I'll produce those text messages to show that Marty McFly is in your real world. Marty McFly has offered to meet you and you pussied out and had nothing to do with it. You're a bitch, George. You're a bitch. Get off the internet and get off the TV. People will stop talking about you. Stop attacking people and people will stop coming after you, you fucking bitch. Also, guys, as a little treat for you, I thought I'd let you see something. I thought I'd let you see something that George ain't happy that news reporters take pictures of his house when he's out making public claims and he's a celebrity on the TV. Oh, look at that. That's George's house. And do you know what this is, guys? This here is a new car that George has bought. And look at that dashboard, covered in newspaper. Like your life, George. Is that all your life in there? Is that because you're living in this van, George? I think you are. And also, he leaves the porch light on during the day. That's because he doesn't pay his electric bill. He's willing to do it. Guys, I have been Marty McFly. This has been a short one today, but I hope it's been one that's brought you some enjoyment. More Marty McFly Investigates videos to come in the coming weeks. Anything that happens at the court, I will bring you the latest updates. Sean, Will, it's been a pleasure. I am Marty McFly, signing off.